So should we begin?
Yes, sir.
So Nandini, we are ready to start.
Yes, sir. Yes, sir. We can begin.
So good evening and welcome to everybody for this important discussion. We have a very eminent panel, so I'll just take a minute to introduce our panelists. We have Dr. Nazim Zaidi. Good evening, sir. Long time we haven't met. He was,
Good evening. How are
yes,
you?
good evening. Yes, sir. Fine. He was the Chief Election Commissioner of India, no less, from April 2015 till he finished his term. He has had a very distinguished career, not only as a Chief Election Commissioner, but in the civil service. He held very important positions in the Indian Administrative Service, particularly in the Civil Aviation Ministry. And he is also highly literate. He has a PhD in chemistry, and he also has a master's from the Kennedy School of Government in Harvard, and he has also been a Mason Fellow at the same university. We are very privileged, sir, that you are with us, and we look forward to your learning from you.
Thank
we
you.
also have, we also have Dr. KVK Shanti, professor. We haven't had the privilege of meeting, but we have heard about you. She's holding a very high position. She's a proctor and professor at the Osmania University. She's a very distinguished scholar and also different types of degrees. She has a BSc and an LLM and a PhD. And she has also specialized in the criminal justice system and has a lot of wealth of knowledge, which we expect to hear from her. And she's also been a scholar overseas, including at the Max Planck University Institute, rather, in Germany. So welcome, Dr. Shanti, and we are very happy that you found time to meet us. We have an equally distinguished another panelist, Poonam Agarwal. We also haven't met, but we have heard about you and, of course, your organization. She's the editor investigation at Quint, and she was also a well-known TV journalist. She believes in fact-based and in-depth reporting, and she has also got a very prestigious award called the Ramnath Goenka Award. So Poonam ji, welcome and thank you for joining us. We are expecting one more speaker, but I think we will begin and we will introduce the other speaker as and when she arrives. So the format is very simple. We have about 10-12 minutes for each one of you to speak. I would strongly request that we stick to our time. The topic is well known. It's the issue of criminalization in politics, and we saw the opening film or video which ADR has shown how things have progressed over the years, if you may use the word progress, where the level of criminalization is actually increasing. And so I just want to give a 2-minute perspective. So there are 3 or 4 issues here. One is, of course, what the Election Commission itself and can do and is doing, and what are the constraints they face in addressing this. The other is, of course, the political system itself. What is the nature of that political system? And third is, of course, the voters themselves. To what extent are voters engaged with this issue, and are they paying attention to it or not, and what can we do? And I'm sure we will learn a lot from each of the speakers. So I have no particular order, but if anybody volunteers to go first, we can ask them. Otherwise,
I can go.
welcome, Dr. Zaidi. We are eagerly looking forward to your remarks.
Okay, yes. So good afternoon to everybody. Thanks to the ADR for this invite to share some of my thoughts. So just now we saw on the screen that ADR has conducted studies to show that the number of contesting candidates with criminal background has been increasing in past 2 decades, and a good number of them have charges of serious criminal offenses against them, which can result in imprisonment for 5 years or more on conviction. And of course, when these candidates are elected, they are also sitting as lawmakers in various legislatures. And it was also shown by these studies of ADR that many of the elected members had uh, charges of serious offenses framed against them at the time of their elections. So another important thought, which I think we must share just in the passing, that it was the clear intention of the constitution framer that the legislature should have persons of integrity who are going to occupy important positions of responsibility, authority, and powers, so that they can serve people of India. And therefore, keeping this intention in view, the Constitution and the R.P Act have provided certain qualifications and disqualifications to screen out good from bad. And these disqualifications, particularly under the R.P Act, were to fulfill the intention of our Constitution framers. But the existing legal framework has not been able to serve the purpose, and still the people with criminal backgrounds are entering into our polity and august institutions. So very briefly, let us see why our current legal framework has not been able to be successful. And without getting into the discussion of the constitutional provision, much, I'm sure the audience is very well aware that the R.P Act under Section 8 provides that persons will be disqualified on conviction of certain offences which are listed under Section 8, 1, 2, and 3. In fact, if you count under Section 8.1 and 8.2, there are about 16 acts under which various offences can be disqualify upon conviction. And there is one general subsection 8.3 which says that conviction of 2 years or more under any other offense can also disqualify the person. But the basic point here is that it is only upon conviction and not before that. And why the current provisions of disqualification have not been successful, and various studies have shown that in spite of these disqualifications, the number of people with serious and general criminal background has been on the rise. So, of course, various reasons have been found out. One is the low rate of conviction. Another is the delay in disposal of such cases before the courts. And when persons get elected, they also use their position to influence and delay the process further. So the basic point is that the Section 8 operates only upon conviction of cases as defined under Section 8. And this is the reason that Section 8 disqualification have not been very successful in preventing the people with criminal backgrounds to enter into legislature. Another thing with Section 8 is that it does not provide for disqualification of persons against whom charges have been framed by the court for serious offences, and you already know which serious offences these are, and and these are punishable with imprisonment of at least 5 years. And of course, there is a cutoff period. The time at which these charges have been framed. And it is not that this particular point of deficiency in the disqualification of Section 8 has not been engaging the attention. In fact, for past 2 decades, more than 2 decades, In fact, since 1998, this issue has been flagged that until unless we have provisions under Section 8 for disqualifying such persons who have charges framed against them for serious offences, unless this is provided in Section 8, we may not be able to reverse the trend of increasing criminalization. But the most important thing that has struck me is the topic of the discussion today, and that is the institutional laxity. Whether any of the institution has been lax in making efforts towards decreasing or curbing the trends of increasing criminalization. So there are at least a couple of institutions involved. We begin from the top, like legislature, executive, judiciary, particularly Supreme Court, Election Commission of India, and I also include civil society organizations, political parties, and voters. And there is also a body called the Law Commission, which sits in a way independently but works under the executive. So now, first of all, let us look at Law Commission. I think, in my view, the Law Commission has done its work very splendidly. The last recommendation of the Law Commission was in 2014, and they made the recommendation on similar lines, like disqualifying persons against whom charges have been framed, and they have laid down various conditions. I don't need to get into details of those things. The Law Commission also made recommendation in respect of sitting members of legislatures, and again there are certain conditions which have been laid down to elaborate on these disqualifications. So these recommendation of law commissions were submitted to the executive, and in I think 2014, and since then they have been sitting over there. The next set of institution is Supreme Court, Election Commission of India, and civil society organizations together. So if I look at Supreme Court, I think it has made the most effective contribution to curb the trends. I won't say it has been very successful, but it did commendable job. I would not get into the number of PILs which were filed by CSO, but basically in these PILs, the Supreme Court has struck down certain provisions of the Representation of People Act, like Section 8(4), like Section 33B of Representation of People Act, and then made efforts on increasing the transparency about criminal records of persons. And again, ADR has been the leader in this regard. It was on their PIL that Supreme Court issued direction to file affidavit with regard to criminal record, etc. I will not get into the details in those pages, but this trend continues before the Supreme Court. And then, in my view, I think the attention or the focus of Supreme Court has now gone towards political parties. So they are they made attempts to fix the responsibility or the accountability of political parties in making it mandatory for them to publish details of criminal antecedents of candidates, and there are various channels provided in the directions and timings, etc. I will not get into those details. So it seems that political parties did not take their directions very seriously, and then this followed a spate of contempt of court cases. But in the most recent election, Supreme Court has again asked Election Commission to comply certain things, and political parties. I'm told a special cell has been set up in the Election Commission to monitor the cases of compliance of order of Supreme Court. A dedicated account has also been set up in the Election Commission, where the fine imposed on political parties will be deposited to run the extensive awareness campaign. And I also understand Supreme Court has imposed fine ranging from rupees 1 lakh to 5 lakh, which I believe has been deposited with the Election Commission of India. So I think the most important trend that has taken place in the recent years is that Supreme Court has raised the bar of accountability to political parties. I hope political parties will pay serious attention towards compliance of the order of the Supreme Court, and I don't rule out that Supreme Court might use harsher methods in future for non-compliance of law. No, they cannot make law, and they have said so in their judgment that our hands are tied and we cannot transgress into the areas reserved for legislative arm, and therefore we have reached a kind of dead end at the level of Supreme Court, where they have made it very clear that we cannot frame law until unless there is a void where they can invoke Article 142. And the next institution out of these three institutions is that civil societies, and I must commend their role because they have been the ones approaching the Supreme Court and seeking direction. Now, sometimes point is also raised regarding the Election Commission. So, Election Commission, of course, again cannot frame laws because under Article 324, its powers are limited because they cannot legislate in areas where there is already a law, as for example, in this case, for disqualification of uh, of candidates, and therefore Election Commission of India has been implementing the orders and direction of Supreme Court from time to time. However, I note one very important point which I would like to share here. I think Supreme Court in one of recent judgments said that they also expressed their immense anguish for the Election Commission cannot deny a candidate to contest on the symbol of a party if they are having if they are having charges framed against them for serious offences. I think somehow this issue needs to be flagged. Uh, Either Election Commission initiate suo moto, or maybe CSO once again approaches the Supreme Court to issue direction to Election Commission of India to examine it and whether they can deny symbol uh, to candidates who are seeking elections, and if they have charges framed against them, this can be done probably under the symbol order, where Election Commission has sort of competence to issue orders, but that needs examination. This provides a little ray of hope for future. Then political parties, of course, they always prefer candidates with serious criminal offences. Quite a good chunk of candidate has serious criminal offences. They always, as ADR just showed, they have better chances of winning. They have good amount of money with them, and political parties prefer such candidates because the process itself is opaque. And I mean, political parties are giving reasons for selection of these candidates which are not very convincing. If you go through the explanation given by political parties for selecting such candidates, they are not very convincing. So I have my own views on that. Now, the last category of I will just take 1 or 2 minutes more, Professor Shastri, if you permit. The
Yes.
last category of persons who can play some role is a voter, but voter themselves succumbs to the din and bustle of the electoral campaign, in the words of Justice Venkat Chalaya, and they are influenced by religion, caste, ethnicity, and therefore they are very prone to influence by muscle and money power of contesting candidates. I have a view in this regard that in spite of efforts of CSOs and Supreme Court direction on affidavit, actually the information about affidavits has not really percolated down to the level of voters. In the initial years, they remained confined to the records of Election Commission, returning officer, or at the most on the website of the Election Commission. It has not really reached the voter, and therefore, in light of recent Supreme Court order that Election Commission must go down to the level of voter, to inform them about candidates. I think the election commission will have to reorient its entire awareness campaign as to how to get down to the level of voter with information about criminal antecedents of our candidates. And in the final analysis, I will say one more point that although we are focusing on disqualification aspect, but in my own view, there is a great nexus of money, muscle, political finance, anti-corruption, political parties, and therefore beyond disqualification, we need to have a wider plank of laws. Finally, and then I will close. I believe that political parties will have to play a very significant role. In fact, a suggestion was made to the government in my last days that they must set up a standing committee of. They must move a proposal before the parliament to set up a standing committee of the parliament on electoral reform. Then political parties in the parliament must create a consensus to agree to whatever commonly agreed proposals are and then get going. Unless that happens, probably our efforts to decrease or to curb the increasing trend may not achieve great success. So these are some of my thoughts which I thought I will share. I exceeded by 3 minutes. I'm very sorry for that. Thank you, Professor
Thank you
Shah.
so much, Dr. Zaidi. Very insightful. We have noted a couple of points on which we will have an internal discussion and see how we can implement your suggestions.
Thank you.
But, yeah, I think we will continue with the more academic point of view. So, can we invite Dr. Shanti to give her comments, please? I think she's muted. Yeah.
Yes, sir. I think I'm audible.
Yes, yes.
Uh, um, Honorable former Chief Election Commissioner Dr. Zaidi sir and Professor Trilochan Shastri sir and Ms. Poonam Agarwal from Quint, very popular journalist, and all the respected audience of this seminar. As I come from law background, I have chosen to pick the directions given by the Supreme Court to improvise the quality of the political system of this country. So, I have concentrated, or I would like to focus on the very recent judgment given by the Supreme Court in Brajesh Singh versus Sunil Arora, the judgment was delivered on 10th August 2021, and it has, as rightly pointed out by our respected speaker, my previous speaker, the Supreme Court has expressed its anguish, and they have also warned the governments, central governments and the state governments to take some immediate action. I appreciate Association for Democratic Forum for taking up such an important issue and for creating awareness among the voters. So the Supreme Court in this case has mentioned that there has been an alarming increase in the incidence of criminals in politics, and from 2004, where the percentage of the criminals in the members in the parliament was about 24%, has risen up to 30% in 2009, and in 2014 it has gone up to 34%, and in 2019 almost 50% of the parliamentarians have criminal cases pending amongst them. So, if we look at the categories of offences which are committed by these politicians, in my view, I have categorized them as three. The first category belongs to the acts committed, which can be named as riots, and Delhi riots could be a very good example for this one. The political parties, to further their own goals, they generally participate in these riots, and that they may commit many serious offences, including murders, including homicides and vandalism. And the next major number of, or 90% of these politicians are involved in corruption cases, like earlier Chief Minister of Tamil Nadu, Jayalalitha, Madhu Koda, Lalu Prasad Yadav was even convicted. We have number of scams. We have number of ministers at both central and state level. The third one is election offences. During the elections, many kinds of offences are committed by these politicians. So these are the three kinds of offences I thought which will be generally interesting us when we talk about the politicians. So, what is the why are we talking about the criminalization of politics? Because it would affect the principle, it is against the principle of free and fair election. When one uses money or muscle power in elections, it limits the choice of voters to elect a suitable candidate. We have heard that in some constituencies in Bihar and now in state of Andhra Pradesh also recently, people voters are threatened, they are warned, they are forced to vote to a particular party. So this, if it is against the ethos of a free and fair election, which forms the bedrock of a democracy. Of course, secondly, it affects the good governance. The major problem is that the lawbreakers become lawmakers, and this affects this efficacy of the democratic process. And it causes a kind of a social disharmony also, because it introduces a culture of violence in society and sets a bad precedent for the youth to follow and reduces people's faith in democracy as a system of governance. In Brajesh Singh Mishra, in Brajesh Singh's case, the Supreme Court has given certain directions, and they were referring to a public interest litigation which was filed by ADR only. That I won't read entire thing, but just one or two I would like to point out here, that they asked the election commission to incorporate the none of the above option in the voting machine, and establishment of special courts in all states for the quick disposal of cases involving elected representatives. This special courts also has become a controversy, because in Madras High Court a committee was appointed and they have taken an objection to it, and they said that of the we can't have special courts only for politicians, and this entire setup has to be offense centric but not offender centric. That is what they have said. Again, a reply was filed in Supreme Court, where Chief Justice of India N.V. Ramana also has taken it up, and they have issued again orders saying that no state can withdraw any case which was filed against the politicians using Section 321 of CRPC, which is called as withdrawal from prosecution. Then this is the case. I mean, this is the case in which they have given the directions: Public Interest Foundation and others versus Union of India. Each contesting candidate shall fill in the form as provided by the Election Commission, and it has to state in bold letters with regard to the criminal cases pending against the candidate, and political party concerned shall be obligated to put up its website the aforesaid information pertaining to candidates having criminal incidents. As my former speaker has said, some reasons were given by all the political parties, including Indian National Congress, Communist Party, Lok Shakti Party. They are mentioning some reasons, like I have that those affidavits were also given in Brajesh Singh's case. This leader is a very popular leader. Majority of the voters of the constituency are asking for his leadership. Something like this they have said, which were clearly not very much convincing. And of course, reading of Section 8 would show that apart from certain grievous offences and convictions, it is only upon conviction of a minimum period of 2 years for other offences that a candidate gets disqualified from standing in the election. The Supreme Court has held that the least that can be done, given the present state of the law, is that at least information as to acquittals, discharge, or conviction in relation to criminal offences in the past be set out by way of affidavit, so that a voter can make an informed choice, and including that that none of the above option, because if you may get into a situation where you don't have one candidate also who is not having a criminal case slapped against him. So this in Union of India versus Association for Democratic Reforms and another, which was decided in 2008. Also, some directions were given by the Supreme Court, and recently in on 10th August, some directions were again given to the Election Commission, and they have directed that, or by issuing the Election Commission is directed to call for information on affidavit by issuing necessary order in exercise of its power under Article 324 of the Constitution of India from each candidate seeking election to Parliament or a state legislature as a necessary part of his nomination paper, furnishing the information like whether the candidate is convicted, acquitted, discharged, and prior to 6 months of filing of nomination, whether the candidate is accused in any pending case, and the assets of the candidate and liabilities, if any, and the educational qualifications of the candidate. Now, they've also tried to protect the legislators. They have issued some guidelines to protect these people, and they have issued some other directions like only offences which have a maximum punishment of 5 years or above ought to be included, and charges filed up to 1 year before the date of scrutiny of nominations for an election will not lead to disqualification. Like this, some protections were given to the legislators as well by the Supreme Court of this country. And the contention now the like why should we inform the voters? This is a big question which has come up before the Supreme Court. Is it a fundamental right of every voter to know the prior criminal record of the legislator? That is one objection which was raised in the Supreme Court in number of cases. So, this contention, as there is no such specific fundamental right conferred on a voter by any statutory provision to know the antecedents of a candidate, the direction given by Supreme Court are or against the statutory provisions is on the face of it without any substance. In an election petition challenging the validity of an election of a particular candidate, the statutory provisions, of course, would govern respective rights of the parties. However, voters' fundamental right to know the antecedents of a candidate is independent of statutory rights under the election law. A voter is first citizen of this country, and apart from statutory rights, he is having fundamental rights conferred by the Constitution. So they have every right to know about the uh, prior criminal antecedents of the person who stood in the election. Now, political parties were supposed to publish the information regarding criminal antecedents of candidates on the home page of their websites, thus making it easier for the voter to get to the information that has to be supplied. Of course, it would also become necessary now to have a home page with a caption which states candidates with criminal antecedents. Like this, some more directions were also given in Brajesh Singh's case. Now, 12 special courts were being set up across 11 states exclusively to try sitting member of parliaments and MLAs. I mean, Delhi has two such courts: AP, Telangana, Karnataka, Kerala, Tamil Nadu, UP, Bihar, West Bengal, Maharashtra, and Madhya Pradesh have one each. And these special courts in each state would have jurisdiction over the entire state, while the two in Delhi would cover cases within the province of the Delhi and partly Delhi. Now, I've told you that Madras High Court took an objection to it, but when we have 4,400 and criminal trials are pending against legislators, of this, over 2,005 trials are involved sitting legislators. Maybe this step is necessary, but the Madras High Court's Criminal Rules Committee on Special Courts for Trial of Criminal Cases against MPs and MLAs, which consisted of Justices P.N. Prakash and Jayachandran and N. Satish Kumar, they have said that special courts could not be set up on the basis of judicial or executive orders. They took a technical objection to it, and they have said that special courts can only be constituted by a statute, not by executive or judicial fiats. And Madras High Court had argued that it is not legally permissible to set up such kind of a court. But in a significant, then the matter was again taken up by the Supreme Court, and the Supreme Court has said that nothing doing, this is the need of the hour, and it also had curtailed the power of the state prosecutors. So it has come to the notice of the Supreme Court that in many states, including state of Karnataka, the state government started withdrawing the from prosecution against all those relating to all those criminal cases which were filed against the politicians. So it is a power given given by CRPC under Section 321 with a title called as withdrawal from prosecution because of positive evidence, because of some urgent situation. A prosecutor can withdraw from prosecution. So that power they have started using, and they have started protecting their legislators. So then the Supreme Court, under the leadership of the present CJI N.V. Ramana sir, he has issued an order that nobody can withdraw prosecution against any lawmaker without prior sanction from the High Court. Section 321 says that you can withdraw from prosecution, that is, the prosecutor can withdraw from the prosecution just with the consent of that particular court. But here they have put a rider. They said you cannot do it without prior sanction of the from the High Court.
Dr. Shanti, can I request you to wind it up because
Sir, it's over. It's over, sir. Just 1 minute. Thank you so much. So the way for recommendations also, I mean, we have to forward some recommendations. This is what I have understood from our agenda. So some various committees like Dinesh Goswami Committee, Inderjeet Committee on Electoral Reforms, they have recommended for state funding of elections. This could be one way forward. Secondly, strengthening of the Election Commission. Election Commission can register a political party but cannot deregister it. Regulating the affairs of a political party is essential for a cleaner electoral process. Therefore, it is imperative to strengthen the Election Commission. Of course, we at the last but not the least, we require a behavioral change in the voters also. Voters need to be vigilant about the misuse of money, gifts, and other inducements. Thank you for the opportunity given to me. I thank Association for Democratic Reforms. I thank my fellow speakers and the audience for giving me a patient hearing. Thank you.
Thank you, Dr. Shanti, for that very informed and very persuasively argued presentation. We will have taken note of it. We will try to do something about it as well. So we have our third speaker for the day. That is Ms. Poonam Agarwal. So Poonam ji, over to you.
Thank you, sir. So my time starts now for 5:41. Okay, I'll quickly say, as a journalist, my perspective is as a journalist. I am unlike Dr. Zaidi and Dr. Shanti. I have not really dealt with this issue very closely, but I've spoken to the voters. I've spoken to the Election Commission seniors. So even the judicial part. So I would, when we talk about laxity. So the fact that the number of candidates who are having criminal charges are increasing in the election process for various reasons. It's just not because of one institution. But we have to put it in a perspective, like who benefits out of it. Political parties are benefiting out of it, no doubt about it, because the winnability of these candidates are much, much higher compared to any other candidate with a clean background, because these people have muscle power, they have money power. And again, as we all know that the religion, caste, creed, all these cards play very important role in election. Even the voters who might be aware of the criminal cases against a particular candidate might not give that importance to this particular aspect, rather look into the fact that the candidate belongs to my caste or religion or could be beneficial. So I would like to put 2-3 things here as a solution. Now, where is the solution? Problem, all of us are aware of it. Dr. Shanti has spoken about the problem extensively. Dr. Zaidi has pointed out like judicial system can work on it. We all remember 2G scam case. 2G scam case, it happened during 2010-11. A special court was set up. Dr. Shanti said there are various problems. A special court was set up in 2G scam so that the the legal system could be expedited. And it did. Within few years, we found that the judgment was out. Now, I am not saying that a special court per se should be set up for all these candidates, political candidates who are facing criminal charges, but the least that the Supreme Court can do is that at least put a time frame. A stipulated time should be given to the court to decide on these criminal cases, because what we are seeing that the criminal cases are going on for years, for 10 years, 12 years. By then the public memory is very short, nobody remembers it. So why not a stipulated time be given to all these cases, and maybe it could be a year after the charge sheet has been filed, or maybe overall. It depends on the what the best suited method is, instead of just giving a designated special court, because that will again take away resources from the court. So maybe a stipulated time frame. In that, what will happen that there are a lot of controversy on the charge sheet aspect, that Dr. Zaidi said that that is the best way out. But again, the charge sheet is not conviction, and as we know, until and unless a person is found guilty, he is innocent. So in this, which I also personally strongly believe, so charge sheet might not be the final conclusion that the person is guilty of the crime alleged against him. So that will again give him some amount of gray area. So in that case, a stipulated time period would be a beneficial way to find a solution to this problem. Secondly, as far as the election commission concerned, they keep on telling political parties on the basis of the Supreme Court guidelines that awareness, the advertisement should be put out by the political parties or the candidates that they have these criminal backgrounds. My question to election commission is that they put out so many videos and advertisements and campaigns on that the voters should go out and vote, why voting is important, and all these acts. Why can't they run a campaign on the fact that your lawmaker could be your lawbreaker, as Dr. Shanti said? That why can't they create, why it a campaign should be there focusing on the fact that why one should not vote a person who has criminal antecedents, how it will harm our democracy. So this will at least make people think about it before, because this is not being talked. I've been on ground. Even this is not the first thing which we talk about the candidate, whether having criminal antecedent or not. So such campaign on part of the election commission, because election commission is there for awareness, to make voter aware of their rights, what all they should do while voting. So this one aspect maybe I think will be very helpful for the voters, because they will also think about it, why I should not vote a person who has criminal cases against him, because we don't find voters talking about it. So this is one aspect. As far as the political parties are concerned, I don't have much hope from them, because I spoke to many politicians. They feel that having criminal cases is like a qualification for them, because they have money, they have power, and they have good control in their constituency. So political parties might not be bothered about it. But the judicial system and the election commission, these two institutions can really make a lot of changes and difference to our election process, because this is one subject which ADR had been talking about and discussing about, but on ground when we go, this is not being talked about. As a journalist also, I feel that we do read about the candidates and their profile when we in the print newspapers, and we do read, but there isn't much being done about the fact that why these candidates should not be voted. Because when you go on ground, you see that these people who have muscle power, they have a different kind of clout among their people. Some of them are considered to be Robin Hood, so we have to bring out these facts to the people. What harm are we going to do to our democracy if these people come to power? So I would like to sum up on these 2 points, that maybe the Supreme Court or the legal institution, they should think about making the entire process very much time stipulated so that things get concluded, and the person, if found guilty, he or she is not allowed to contest any further. But it is, again, it may very much depends on the Supreme Court or the judicial system to decide on that. Thank you.
Thank you so much, Poonam ji. Very passionately spoken. I used to be like you when I was young. नहीं, बिल्कुल
Thank
आपने
you.
ठीक बोला. Thank you so much. So we do have time for Q&A, but I just wanted to add one more fact to the wonderful things that the speakers have said. I was just looking again at our ADR website, and it says that the central government, that is the government which is in Delhi, out of 78 ministers, 33 of them have a criminal case against them. And this is true in many state legislatures as well. It's not only the elected MPs and MLAs, but ministers who have been sworn in and who are actually have a fair amount of power and authority are actually having criminal records. So the political leaders, they are well aware of all this. So it's not only about winning in this thing; they actually welcome them into the cabinet as well. So this is another matter of serious concern. So, Nandini ji, if there are questions, I mean, I can also keep on talking, but I think we would like to hear from our speakers and how they respond to any questions that we may have. Or if you need 5 more minutes, I can make a few remarks till the questions are ready. What do you advise? Nandini, do we have questions from the speakers?
Yes, sir. One question, I think I can see on the screen. Is there
No,
any law?
no, what we have decided is that there'll be hundreds of questions, so the team will try to filter them out, and yeah, because we've been running these webinars, almost every week, so some of the so Nandini, are you here, or you're muted yourself, or what is the situation? Yeah. Mm. Yeah, so some of our well-known supporters and friends are here with their questions.
Sir, we can start Q&A session.
Yeah. You are the moderator of the questions, I think. So, would you like to read them out or display them, or how do we do this?
Sir, I'm displaying the question.
Displaying the question. Yes. So, this is, I think all of you can read it. So, is there any law or rules under which political parties can take foreign donation? If yes, will it not amount to interference in the electoral process? Commodore Patra. I think all the speakers are aware of this. So, whoever wants to answer this is most welcome.
Well, this is Naseem Zaidi. Well, I think the law is very clear that political parties, registered political parties in India cannot accept foreign donations, and exactly for the reason that you have stated in your question, that this might lead to interference by foreign sources in the electoral process of this country. Some outsiders may try to tinker with our democratic process, with our conduct of free and fair elections, and that is why this law has been laid down. So the law is very clear, and I'm sure the audience would be aware of the famous case, which is, I think, still pending at higher levels of courts, and that is with regard to two major political parties of this country, where cases have been filed under FCRA, and they are challenged by political parties, and they are pending at higher level for judicial scrutiny.
Thank you,
So,
Dr. Singh.
Thank you.
Actually, ADR filed a case and won the case in the High Court, and the
Yeah.
High Court has held both these political parties. We are in one is the BJP, the other is the Congress. Both of them
Right.
have been held guilty of receiving foreign donations, but they changed the law retrospectively in Parliament, which is not a constitutionally correct thing. So ADR has challenged that law also, and it is pending in the Supreme Court. And question is, why can't NGOs are not allowed to take foreign funding, but political parties are doing it and getting away with it, but there's no action taken against them. So yes, let's move on to the next question. Commodore Batra is a very well-known friend, leader, advisor, and he has done some landmark work in the right to information domain in India. So glad to see that. Glad to see you, Commodore Batra. हाजी अजीत पटेल, देश में लगातार विधायक और सांसद इस्तीफा देकर तुरंत चुनाव कराने पड़ते हैं। इसको लेकर क्या किया जाए जिससे जनता को पैसे दुरुपयोग नहीं हो, या 5 साल के पहले पार्टी बदलने पर चुनाव लड़ने पे रोक लगाया जाए। तो ये अजीत पटेल जी हैं, वो हिंदी में पूछ रहे हैं, बट वॉट एवर लैंग्वेज यू वांट टू आंसर इन इज, so this is a this is a legal matter, but either Dr. Shanti or Dr. Zaidi, whoever wants to.
Sir
आप
will
हिंदी
speak.
सीखते हैं डॉक्टर शांति, हिंदी అర్థమవుతుందా మీకు?
అర్థమవుతుంది అని సార్, let sir can, I think sir is better informed
Okay.
about it.
Okay.
Sir, I request Dr. Zaidi sir to answer this question.
No, thank you. ये प्रश्न जो विधायकों द्वारा इस्तीफा दे के चुनाव कराने का है, तो ये बात सही है कि किसी न किसी आधार पे अक्सर विधायक और सांसद इस्तीफा देते हैं, और फिर उसके बाद उस क्षेत्र में, चाहे वो लोकसभा का हो या विधानसभा का हो, वहाँ पर दोबारा चुनाव कराने पड़ते हैं, और उसमें पैसा खर्च होता है जो सरकारी कोष से जाता है। तो इस विषय को कमीशन ने भी रिकमेंड किया है कि अगर ऐसा होता है तो ऐसे मामलों में दोबारा चुनाव अगर होता है तो उसका खर्चा जो है वो ऐसे व्यक्ति से वसूला जाए जिसके कारण से ये बाई इलेक्शन कराना पड़ा हो। और ये मामला गवर्नमेंट ने लॉ कमीशन को भी भेजा था, और उन्होंने भी इस संस्तुति को इलेक्शन कमीशन की सही पाया है और रिकमेंड किया है कि ऐसा किया जाए। बट जैसे मैंने अपने कमेंट्स में कहा था कि ये सब रिकमेंडेशन जो लॉ कमीशन की थी 2014 की, ये सब अभी हमारी कार्यकारिणी के पास हैं, और अभी तक उन पर कोई आगे प्रोसेस तो हुई नहीं है, और हम सब लोग वेट कर रहे हैं कि शायद कोई किसी दिन इन चीज़ों पर एक्शन हो। तो ये मेरा इसके ऊपर टिप्पणी है।
थैंक यू सर। जो हम आम भाषा में कहते हैं कि ये सारे रिकमेंडेशन जो हैं अभी कागज के फूल हैं। चलिए, लेट्स गो टू द नेक्स्ट क्वेश्चन। Katyayani ji, welcome. She is also an old supporter, friend, co-worker in our the general civil society. So thank you for being with us. Why can't the Supreme Court hurry up in deciding these criminal cases? As it is, they're supposed to decide the cases. Maybe I will try to answer that. The Supreme Court has, as you have said, given a judgment many years ago, I think 6-7 years ago, that all these cases should be done in 1 year, not through special courts, but they gave direction to the various high courts. So we have been trying to follow it up, but the high courts have been unable to decide these cases in 1 year. And we really don't know whom to hold accountable, whom to hold in contempt for this. So it's a very good point. And the special courts, we already had a discussion. Both our eminent speakers said that the Supreme Court has said that special courts are required. So let us see what happens. I think we'll have to collectively pursue this. Thank you so much.
Special courts are constituted, sir, but the procedure is the same.
Yeah.
So the procedure gives them, that again, that leeway, that time they can buy. They have all sorts of, they can play their games and they can take an adjournment. They can do
Correct.
everything.
Yeah. So the adjournments is another. That's a
Cases are
judicial reforms issue. That's another issue. Yeah.
not only political offense, sir. Like you take a rape and murder cases are there. Children are killed and murdered. The POXO cases are every criminal case is urgent. That way, every criminal case has to be disposed of within 1 year or even if possible lesser in a lesser time. But they
Yeah,
are
you are a
overburdened.
lawyer. See, I mean, we go by examples from other countries. I am aware that in the United States, they fix dates for hearing, and it doesn't matter whether the party is present or not. They say that within 6 months to 1 year, the case is decided, and we just drag it on for years and years. Anyway, it's an important subject. Let's have the next question. Now, we want to give everybody a chance. Hi, Shaheen ji, namaste. Can the candidates be mandated by SC or EEC to declare the criminal cases and all the speeches and the pamphlets and public city materials? Yeah, I think the EC will have to answer this.
Well, I think in a way the Supreme Court has already given directions. Actually, I am not very clear about the intent of this question. Is it the declaration of criminal cases which have been registered from before, or is it the criminal cases which are arising out of their speeches during election campaign?
No, from before. From before.
From
Very
before. Like sir,
from before.
we
From before.
नहीं, जब
Okay,
इलेक्शन
okay.
में भाषण देने जाता है, he should say कि
like
I want to
smoking
tell
is
you.
injurious to health, ऐसा करके they have to publish it in each pamphlet,
I
something
see.
like that, something
I
like
see,
that.
I see. So this is one step above what all has already been decided. So I think we will have to wait for the appropriate time to come for doing that also. And I think our civil society organizations will have to take up this also, that they must declare it during
In their
their
campaigns.
public speeches. You know, the
But
election commission. Sorry, I will just answer very briefly. Election commission has not been very forthcoming in respect of declaring or disclosing the information about candidates at polling station level, at returning officer level. And when I was in the commission, I used the speaker, Professor Shastri, no, Professor Santi mentioned that why should voters know it? So in the commission, there was a view that commission has no role to play in declaring their criminal background at polling station level or village level or returning officer level. But I am glad that with the direction of Supreme Court, that attitude has changed. Now the commission is sort of required to disclose that. Of course, political parties are required to that. Candidates are required to that. I think a time will come when this will gain wider publicity, and declaration of these criminal cases when candidates are giving their speeches may not arise actually. Maybe the voters are very well informed from before due to the publicity by political parties and candidates and election commission by their awareness campaign. I hope that situation may not arise in future.
Thank you. Shahinji, just one information I want to share with you. The local elections, panchayat elections and municipality elections are not conducted by the Election Commission of India, but by the respective state election commissions. So the State Election Commission of Maharashtra, which is independent of the Election Commission of India, they have actually, in one of the elections, they displayed on the polling booth the criminal records of the candidates. So my suggestion to Shaheen is that why don't you file a PIL asking that this should be done in the assembly, and because if the court says so, the election commission will be duty bound to agree with that. So all of us need to participate. Don't leave the entire burden on ADR. But very good question, and thank you. Can we have the next question, please? Mr. Mahendra Shah, the problem is with the courts because there is a long gap between accusation and conviction. ADR should come out with data about how many convicted criminals. That convicted criminals are not elected, Mahendra Shahji. It is only the people who have got cases pending against them. Charges have been filed. They are the ones who are being elected, because the law is very clear that once you are convicted, there are some ifs and buts. But once you are convicted, you cannot be an MLA or an MP. And you will notice that two of our great leaders, one is Mr. Lalu Prasad Yadav. He is unable to contest elections because he has been convicted by a high court, although the case is pending on appeal, etc. Similarly, Jayalalitha was unable to contest elections for some time because she had a case pending against her. So the law is very clear, but they somehow escape conviction or delay the matter. That is the real problem, which you have also pointed out. Can we have the next question? The criminality of candidates transcends to the EC staffs and workers, as many a times candidates, booth observers and candidate workers also have this. We don't have information. I don't know. Maybe somebody, maybe Dr. Zaidi, you'll have to comment on this.
Yes, there are instructions of the commission that when what you call as polling agents or counting agents, whom you are referring to as candidate booth observers, are screened in terms of their criminal antecedents. In fact, police report is also obtained when the candidate files the names of their counting agents. Is a antecedent checkup from the president, and to the best of my knowledge, these polling agents and counting agents do not have criminal background. There could be one or two exceptions which might have escaped the attention. That is there, but another thing is about the candidate workers. Well, that would be a very difficult proposition that even the workers who have criminal background cannot campaign a candidate, because right now our focus is on contesting candidates and elected and sitting members of maybe a time will come and I mean that would be an inconceivable situation where workers with criminal background may allow to campaign for their candidates. So that
Thank you,
is
sir.
what I will say.
Thank you. Follow-up from Mr. Joseph on foreign funds. What about electoral bonds? Are no foreign funds involved here? Well, Joseph, we have a ADR case which is pending in the Supreme Court precisely on electoral bonds. And there is a long history. I will not go into it. But electoral bonds, to the best of our knowledge, are not the same as foreign funds. Electoral bonds are coming from citizens of India, but largely 90-95% is coming from the corporates. The problem is the opacity and the non-transparency. That is the case that is pending in the Supreme Court, that we want to know who is funding these political parties through the electoral bonds. And the electoral bond system has made the funding completely non-transparent. So it's a very, very important question. And therefore, matter is in the Supreme Court.
Sir, I would just like to say something on this question.
Please, please.
So electoral bonds, of course, only the Indian citizens can or the corporates can fund. So foreign funding is not per se there. But again, it's as opacity, the case which is pending in the Supreme Court. So the problem is that how these fundings are, who is purchasing these electoral bonds. So shell companies, and how these shell companies are getting fund, how the money is routed from foreign to Indian shell companies. So there are multiple problems. Of course, direct foreign funding is not there, but yes, electoral bonds is a major issue, especially because of its opacity, and we do not know where the political funding is coming from. As rightly pointed out, that 95% probably is coming through corporates, because individuals, they do not have that much of money to donate. It's only the corporates who are funding. And now again, the question comes like, who are these corporates who are funding these political parties? And who are the political parties? As we have seen in the data which is published by ADR, that maximum electoral bonds have gone to the ruling party. So whether there is more to it, these are the things which needs to be investigated, but everything is stuck in the Supreme Court. As I said in my speech, the problem is that the judicial system needs to take, speedy calls or judgment or order. They need to pronounce speedy orders on these issues, which are related to election or democracy. questions on criminality on the candidates and the electoral bonds. These are major issues. Even EVM issue is lying with the Supreme Court for years. ADR is, of course, is the petitioner in that case again. So yes, the Supreme Court needs to take call on these issues as soon
So,
as possible.
Poonam, suggestion from our side. You are in charge of a very important media. Why don't you write or bring out a story on this issue that the opacity leads to the suspicion that foreign funds may be coming in and breaking the law.
So
And you have given us additional argument, which we will have to go back and see our petition. We can add this argument.
Sir, your petition was filed like it was filed before my story and after my story as well, because I was the one who did the story on the hidden numbers, hidden alphanumeric numbers in electoral bonds. So a petition was filed, additional, I would say, petition application was filed by the ADR. And Mr. Chokar, Jagdeep Chokar is, of course, we were in conversation on that. So the matter is pending. I've written a lot on electoral bonds.
Okay.
I've written a lot on this issue.
Maybe once in a while, once again. Thank you, Mr. Joseph, for that lovely question. Anybody else? Let's move on. My greetings for this webinar. I think we are facing very serious situation. My question is, what is the solution to the culture that whoever is attaining power, either in the state or center, they start the process of taking back their police cases? And so it is seen that many cases are being decided in favor of politicians. Recently, Nainital High Court gave a clean chit to somebody. So I think Dr. Shanti has studied this and even mentioned this issue in her talk. So I will request her to respond to this question about taking back cases.
Yes, Section 321 is being misused by all the political parties. Not only these, every time whenever they come to power, they will withdraw the cases which are slapped against their political leaders, or leaders belonging to their own party. Abdul Karim versus State of Karnataka is a very, popular case in this regard, wherein Veerappan's was kidnapped. Veerappan has kidnapped Rajkumar, and his associates one of his demand was that his associates were to be released. And the Supreme Court, Justice Y.K. Sabharwal, has come very heavily upon it, and he said, you have conspired. They have openly said that the state government, including the Chief Minister and Minister of Home Affairs, they have conspired with the prosecutor, and they have withdrawn the cases from prosecution. So it is politically being misused. So Section 321 also requires maybe some amendment, I think. And courts have to be vigilant here. Even Section 321 says that the withdrawal can happen only with the permission of the court. But sometimes even higher wisdom, is required. That's why Justice N.V. Ramana sir, he has said that the sanction or the permission has to come from the High Court, not from the court where the case is being argued or the trial is being conducted.
Thank you so much for that. This is a very recent pronouncement of the Supreme Court, right?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
So,
it's an interim order they have given.
The other question that he asked is that I do not know the facts, that many cases are actually decided in favor of the politicians even when they are heard. I don't know if anybody has done a study on that. We have not done.
Sir, impartiality of the judiciary is the bedrock of the democracy. We say it on paper. But again, as you have said, this is also a kagaj ka pool only. Number of cases, though we don't have a statistical data with us, but the state governments are in a position to influence the judiciary in that state. And when the case is shifted to or transferred to some other state, or when it goes to the Supreme Court, then only they get justice. So this is a big question on the independence of the judiciary.
Thank you, ma'am. So next question, and please guide us. Till when do we go and what time do we stop? We stop at 6:30, is it more or less? What is our?
So we can take one more question. That will be by by Anil sir.
Yes. So we can read it. Despite efforts of various institutions, 40% of voters still vote for candidates with criminal cases due to caste, religion, etc. How can we break this logjam and vicious cycle? So all of us know Major General Verma. He is a highly decorated person from the army, but now he is doing public service and he's heading ADR. So thank you, General Verma, for this question. So it's a general question. Whoever wants to respond, that how do we break out of this logjam of voters continuing to vote for criminals? Some suggestions were given, but I think this is an important issue. So
No, I think all of us have spoken about voters. Why they vote for why they should vote for candidates having criminal background, and in spite of limited efforts of all the institutions, voters are not very much influenced. Must select candidates with clean record, and there is a list of reasons for which voters vote for persons with criminal records. This could be muscle power of that person. This could be money power, bribing of voters in those constituencies. I'm not blaming voters of all constituencies, but in those particular constituencies, maybe they are influenced by money. Religion is said to be one reason, ethnicity, etc. There are so many reasons, and when the election comes, they somehow get lost in the election campaign. And somebody pointed out that whether they should have a look at the criminal background of candidates doesn't matter to them. They are in a kind of hustle and bustle of election campaign, and just go to the booth and cast their vote under whatever influence. In the ultimate cases, I think it is the voters' education and voters' education and voters' education and nothing else. And maybe in due course of time, with the recent directions, election commission getting engaged into evolving its new kind of campaigning process to go down to the level of the voter, to overcome its initial hesitance. Now it has the backup of the Supreme Court that they must go down to the level of voters. Now, what kind of campaign is needed? They need to consult their consultants and come up with a very effective campaign. That is the only hope in the long run, that our voters would be able to consider the criminal background of our candidates and vote for them. There was also a suggestion that somehow these voters constitute a reduced group of people, and therefore it may not be possible to go down to the level of individual voter, and therefore there is a need for a collective conscience. I don't know how will that collective conscience of the society will evolve, and what kind of people will form part of that conscience. Those are some long term question. When will the social mores of people with respect to electoral democracy in particular will improve? These are all questions which need to be addressed maybe in the long term, but in the immediate term, only the awareness campaign is the answer to wean them away from their established tendencies. Thank you.
So Poonamji, you have very passionately said the election commission should add to its campaign of go out and vote, that don't vote for criminals, etc. In addition, you have any other suggestion from your investigative reports?
No, sir. So I don't have any additional, sir. What we do not, sitting in urban cities, what some of us do not understand, that the voter is not a fool. He or she knows his rights. He or she, if guided properly, will not do things which are not good for the society overall. But the problem is that we all have short-term memory. So once a person is being, an FIR has been filed against someone, and then the case is lying there for 5-6 years, people forget. So here comes the role that the election commission, especially because that's the only institution, a neutral institution who can give us a fair election. So they need to step up and make people remind people again and again that your vote is important. Hence, you have to vote for a person who has a clean background. So here is the need of the campaign. And campaign, we are in a social media era. Campaigning is very easy. Everybody is on YouTube. Internet connection is not a problem. So gone are the days when you need to paste boards and pamphlets on the wall everywhere. Now you can spread the message through social media, and trust me, even media houses will cooperate on that, and they will also bring up this issue again, just like we say that go out, vote is your right, but also vote judiciously is what we need to say. And election commission can, trust me, do a brilliant job on that.
Sir, I just
Dr.
wanted to add
Shanti?
one point.
Yes,
Just
please, please.
one point. Sir, I'm worried about these welfare schemes which are being announced by the government. It is a methodology or a modus operandi they have invented to buy votes from the day one. In state of Andhra Pradesh, I'm observing, sir, if a person is born, there is a scheme. If a person has to get married, there is a scheme. Pension scheme starts from 45 or 50 years. If a person is unemployed, he is given some money. If he wants to get employment, he will get some money to build a house, to get married, to do anything. He will be given money, and every day the government comes up with a new scheme. And this is nothing but, sir, they are buying votes with the hard-earned money of all of us. It is the taxpayers' money, and I think it has to be regulated to an extent. This is not. It is like, he's into the electioneering, or the governments are into this process from the day one. They are buying votes and they are consolidating their vote bank.
Thank you for raising this important issue, Shantiji.
Sir.
I think we just have time. If everybody wants to make any concluding remark, okay. So there's one last question that has come up. Katyayani ji's question. Why can't the Supreme Court invoke constitutional principles and constitutional morality to direct the executive to pass a law to disqualify those against whom charges have been framed? I think we'll ask Dr. Shanti to respond, because she's a scholar of law and she's a provost of Nalsar, etc. So you'll have to take that question, Doctor.
Yeah, what is the second part? I haven't understood it. To direct the executive to pass a law to disqualify those against whom charges have been framed. Starting from the stage of framing of charges itself, she says that they have to be disqualified. So this goes against the very basic principle of the criminal jurisprudence, because unless until the guilt is proven, we can't punish a person. This disqualification also can't be done, because this goes against the basic principle of criminal justice process. This is not possible, sir. Unless convicted, no action can be taken, and nobody can pass a law also.
Okay, thank you so much for all the questions. I think we have to close at 6:30 according to the organizers. So we can take 1 minute each if you have any concluding remarks which you have not been able to state. And then I will take 5 minutes for vote of thanks if that is permitted.
Yeah, my only suggestion in view of what has been discussed today by our eminent speakers and some of the question is that I think the time has come. As I mentioned in the very beginning, that Election Commission did not have a mindset to publicize the criminal antecedents of candidates, and until the orders of Supreme Court came, it continued with that mindset. And now I think the time is ripe for Election Commission of India. I would say it again at the cost of repetition, must reorient their campaign, and as rightly mentioned by Poonam, that they must go beyond creating the awareness about election processes, how a voter should approach polling booth, etc., etc. Now they need to go. They need to, in addition to that, go for voter awareness about um, antecedents of candidate. That is the most important step going forward.
Thank you, sir. Anybody? So Poonam ji, you want to have last remarks?
No, sir, it was very insightful discussion today, and I feel that this issue, we do not talk much when elections approach. It is to be talked. even in TV debates and even opinion pieces in the print. This is one issue which needs to be talked so that people, they remember while voting that whom they are voting, whether the person has a clean background or not. Many of us vote on the basis of political party or even for the candidate, but this is one important criteria, checklist, I would say, very important checklist which should be on the top when we go to vote. So, and this will come on the top only once awareness is created through election commission, through journalists, through various medium, through social media, if people like ADR as well. If we create awareness among the people, then people will be forced to think about it and they will think before voting to their candidate.
तो पूनम जी एक प्रोग्राम इसी मुद्दे पे हिंदी में करते हैं इसके बाद, क्योंकि
हाँ सर, बिल्कुल करिए।
जो मतदाता है वो अंग्रेजी नहीं जानते हैं, वो हिंदी में वोट करते हैं।
मैं आपसे एकदम सहमत हूँ सर, एकदम करना चाहिए।
करेंगे आपकी मदद लेके करेंगे. అండ్ డాక్టర్ శాంతి, ఒకటి మేము తెలుగులో కూడా చేస్తాం ఇదే విషయం మీద, తెలుగులో కూడా ఒక ప్రోగ్రామ్ చేస్తాం.
डिस्क्लोज करते रहिए प्रोफेसर शास्त्री, आपने क्या कहा?
मैंने ये कहा कि यही वाला प्रोग्राम हिंदी में भी करेंगे और तेलुगु में भी करेंगे. मैंने यही और कुछ
लैंग्वेज में करेंगे.
हाँ, हर एक लैंग्वेज में करेंगे, बिकॉज़ शी स्पीक्स तेलुगु, आई एम टॉकिंग टू हर इन तेलुगु, दैट्स ऑल. अदरवाइज वी विल डू इन तमिल, गुजराती, मराठी, बंगाली, हर एक लैंग्वेज में. बोलिए.
राइट.
Yes, sir. Sir, actually, as Ms. Poonam has said, that this awareness program has to continue. And but I mean, somewhere I have a question, sir, that all of voters do know about the criminal antecedents of the person. Few people are elected and now they are ruling the roost as the chief ministers also. It is not that the people doesn't know it, but the investments are higher for them. But I was thinking, sir, at least this right to recall, though it is slightly a rebellious thought, how it would be if you think about it.
Yeah,
can we recall that?
It will require a long discussion, madam, but it's a very important issue. We will flag it for the next time. Right to recall, as you know, you're a scholar, that the right to recall has been given in local panchayat elections in some states for some time, but we don't have it at the assembly and the national level. So sure, we can talk about it. So
thank you so much.
Yeah, our organizers are saying that we're running out of time. So I would like to, of course, thank our speakers for a very wonderful session. And we have actually noted down 3 or 4 points, particularly what the Election Commission can do. And one argument which Poonam gave, that electoral bonds could be actually a source of opaque foreign funds, and therefore there is a need for transparency. Let's see how we can take that forward. And a few things from my side. You see, all these suggestions and some new ones have also come. We have worked hard on it, and with partial success. And all of you, and General Verma's question also was that ultimately the voter is supreme, so-called, and if the voter can exercise his or her rights very consciously, deliberately, and with full information and awareness, then things will change. Because as somebody said, that political parties have not taken a vow to field criminals. They have taken a vow to win elections. If this is the formula that works, they are working on this. If tomorrow we can show another formula works, they will go with that formula, because they want to be in power. Now the challenge really is the voter awareness. So Election Commission, of course, we will gently persuade them that maybe they should do it. And maybe some of the participants in this program can think of going to the Supreme Court, so that the Supreme Court can also take a view on whether they can direct the Election Commission to put up this information on the polling booths and do a campaign for voter awareness, etc. From the civil society side, while what Poonam ji said, that WhatsApp, Facebook, Google, viral videos, all these things are going on, there are a couple of things there where we face a challenge, and that's why we are seeking everybody's help. One is that there is too much of information out there, and there's a lot of fake news, motivated fake news by various political parties, which we have no control over. And number two, the amount of funds that the political parties have compared to the civil society. So the political parties have literally thousands of crores. I mean, what they've declared is hundreds of crores. A few of them have declared thousands of crores also. But actually, what they spend is thousands of crores. Former chief election commissioners have made estimate, not Dr. Zaidi, but one of his predecessors, that something like 70,000 crores to 1 lakh is spent by all the political parties, candidates, everything put together. Now, a small organization like ADR, with great difficulty, we are able to get 2 to 3 crores before a Lok Sabha election to do some campaign, whether it is. So we need to figure out a way of reaching all the voters, and of course, hope that the election commission also does the same. So this is what I just wanted to bring to the notice of everybody, and particularly our participants who have been silently listening and all the people who have asked questions. We need everybody's support to make this happen. You can work with us, you can work independently with us, but our mission is the same, that we have to make our democracy better. And please be actizens, not citizens, active citizens. So if you have to take a word, I stole it from a friend of ours. Actizen means active citizens. So all of us need to be more active. And I hope that more and more people engage themselves in this mission of improving democracy and elections in our country. So once again, thanks a lot for our speakers. I think it was a wonderful session, and we hope to keep taking advice from you and keep taking guidance from you from time to time. Thank you, sir.
Thank you.
Thank you.
Thank you, everybody.
Thank you.
Riyad and everybody. You have given us a new actions, huh?
Thank you.
What citizen and what not. Thank you. Thank you very much.
Thank you very much.
Bye.